Good morning, everybody. Welcome to September's employment coffee break briefing. I think we seem to have had a very decisive end to summer, looking at the forecast, certainly at this part of the country. I don't know what it's like for everybody else. So we are now very much into September. It is the 3rd of September 2025. We're going to be talking today about updates to sexual harassment law, the changes that have already taken place and changes which are coming in the future. I am joined again today by Justine Miz. Justine has now qualified with us, you'll be pleased to know. We know we talked about her joining us during the last session. She is now officially qualified and officially part of the team as of yesterday. So firstly, massive congratulations to Justine. It's a huge achievement, a lot of hard work going into it, and we're really looking forward to having her as part of the team moving forwards. I'm sure most of you will get to know her at some point, either as a client or at future events. Otherwise, today's session, as always, session is being recorded. That will be made available publicly, and of course you will get your follow-up as well. Please, as always, make use of the chat function, the Q&A as we go through. As you all know, these sessions, we do like them to be reasonably interactive. And by request, as I said, sexual harassment. So we are going to look at, throughout today's session, a bit of an overview of the changes to the law around sexual harassment as and when they arise. Before we dive into that, I'm going to ask Justine to look at sexual harassment sort of as it stands and the specific definitions under the Equality Act that we're all familiar with already. And then I'll chip in and start talking about the changes which already took place in the amendment regs from last year and the proposed changes under the Employment Rights Bill. We will do a future session, and just to cover it off, we've got an in-person session at the end of this month which will look at all of the changes under the Employment Rights Bill in a lot more detail, but I will touch on those towards the end of this session. One more mopping up point just to answer a question I've already seen. Yes, I think you do get some kind of certificate to show that you've attended this. I don't know if they go out automatically or if you need to email the marketing team, but if you don't get one within a couple of days, if you email the Events of Friends email address, I'm sure they'll pick it up for you. So yeah, current law, overview of the changes. We'll talk about this shift from reasonable steps to all reasonable steps to mitigate, and we'll have a conversation about how to prepare for those future changes as well. So structure of the session really, Justine on the current law, me on the changing law, and then between us, I've had one or two questions that came through in advance unusually, so I'm suspecting a lot of interest in this one. We'll have a chat about those as well and see where we end up. I suspect we'll run slightly short on this one because it is such a niche topic, but equally I'm sure there'll be a lot of questions either as we go through or towards the end. So as always, we'll dedicate some time at the end to talk about anything that crops up during the course of the session as well. So with that in mind, let's start with the law as it is at the moment. I'll pass straight to Justine, but I think we'll do this reasonably conversation chatty style. So we have got our broad definition of sexual harassment, and of course we're all familiar with this from the Equality Act. Justine, the current law.
Yeah, okay, so hi everyone, thanks for having me on, Chris. So yes, the current law on sexual harassment. So it is a type of harassment which is under Section 26 of the Equality Act. And on the slides, you'll see that there are two different types. The legislation sort of breaks it down into the two different sorts. So we have the first one, which is sexual harassment occurs when person A engages in unwanted conduct of a sexual nature. And then the conduct has that purpose of effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. Lots of words.
I always love that definition because it seems like half a dozen words that all mean the same thing.
Yeah.
But actually, don't mind me chipping in. We've just had funny enough, a case that dealt with a question of harassment. You'll know which one I'm talking about. And they'd actually broken it down into which of those ones was said to have had that effect. I find it strange that the tribunal feels the need to go to that extent, but it does suggest there's a difference in those words, and I always think that's worth bearing in mind sometimes.
Yeah, no, it definitely does. And then that's sort of reflected in the second type that's outlined in Section 26, which is that A engages in unwanted conduct of a sexual nature or that is related to gender reassignment and sex. And then the second part of the test has the same words as we were just talking about above. So the second part kind of relates to a person's gender, identity, or someone who is going through the transitional stage. So that kind of rounds everything off and covers every choice essentially. So in addition, employees can also make a claim if they're subject to less favourable treatment because they've rejected or submitted to any unwanted conduct that is of a sexual nature. So there's the other element that they can bring a claim that way. Then moving on to
next slide, your first next slide, please.
That is next slide, please. So next we're going to look at what actually is sexual nature. So interestingly enough, there is no legal definition of what a sexual nature is itself. It kind of takes its everyday form that we would all kind of know. But there has been technical guidance released probably October last year that says that it includes a wide range of behaviours, and they actually kind of give a list of those things. Those are things like sexual comments, jokes, displaying sexually graphic images, sexual gestures, and then the things such as, touching, hugging, massaging, kissing, things like that. So the unwanted conduct must also have the purpose or effect of violating a person's dignity or creating that, again, intimidating, hostile, degrading, humiliating environment. Looking at the unwanted conduct aspect of it, that can be, verbal or physical. And as I mentioned before, that can include things such as, staring, leering, or displaying explicit material, such as inappropriate emails, things like that. Interestingly enough, the conduct doesn't actually have to be sexually motivated. So the technical guidance does give an example where there's a male worker who alters a pornographic image at work, and he's kind of superimposes one of his female colleagues' faces onto the image. And then he shares it around the office, and that causes other employees to kind of ridicule her. And whilst there's no sexual motivation behind him doing that, because the image is of a sexual nature, that would still fall under kind of the definition of sexual harassment, so that would still be sexual harassment.
Yeah, it's quite broad, isn't it? I think where we're looking at this definition of sexual is what might an ordinary person consider to have some kind of sexual component to it. So, for example, there's a great one. If the intent is, or the purpose even, is non-sexual bullying, we're not suggesting that the individuals in that case were, as you say, had a sexual motivation, they weren't necessarily aroused by what they were doing, which is what we might all kind of take sexual to mean in a lay sense. The fact that there was arguably a sexual component to it in the fact that the original image was sexual was more than sufficient. So it gives us quite this broad definition, both of conduct of a sexual nature, but also that purpose or effect definition, suggesting that quite a lot of things actually could potentially fall into this.
Yeah, it definitely makes the definition far wider. It kind of encapsulates the other stuff that, like you said, isn't necessarily got the purpose behind it.
Yeah. I'll just pick up on one question there because I've seen it come in and I think it's relevant at this point. We will sort of come back to this. You said, is it correct that a bystander can raise a claim even if it's not directed at them? Yes, is the short answer. It's actually an answer to a question more generally about harassment. It applies to all forms of harassment here. An individual doesn't have to have the protected characteristic in order to bring a claim. So in normal harassment of a non-sexual harassment kind, the definition is unwanted conduct connected to a protected characteristic. That's all it takes. Again, so similarly in the sort of sexual harassment case, if you imagine, I think this is one that's given in the guidance actually, maybe kind of that cliche, people have got a porn magazine in their locker, for example, and a third party who doesn't want to see that becomes exposed to it in some way. Yes, they've got a potential claim for sexual harassment. The unwanted conduct is seeing the material. It's clearly of a sexual nature, and if they can demonstrate, as Justine's about to come on to, that purpose or effect, then that ticks the boxes for a potential claim. I'm assuming that's led quite nicely.
I was going to say, you preempted what I was going to come on to next. So we're talking about purpose or effect. So we mentioned about the purpose or effect. So when considering whether the conduct has purpose or effect, the tribunal will consider kind of three essential things. So firstly, they'll look at the perception of the victim, any other circumstances around the case, and then finally whether it's reasonable for the conduct to have had that effect on the victim themselves. So to start with, we think that it is based on how the victim views the unwanted behaviour. It's not based on how the harasser views the behaviour or their kind of intent with it. But there is sort of a caveat to that, which is that, you know, the victim must be reasonable to feel the way that they do, so they can't be hypersensitive. And a sort of good example of this, there was a case that had a lawyer who joined a new firm. After she joined, the manager kind of said to her, "Oh, I'm going for a walk at lunch. Do you want to come join us?" And she declined that. Then a couple of days later, he said, "Oh, we're going as a group of us to the cinema. Do you want to join us with that?" And again, she declined that. She then proceeded to fail her probation and said that the reason that she failed her probation was because she rejected the sexual advances. What the tribunal found was that actually that wasn't a reasonable response. Actually, she was being hypersensitive in that situation because it wasn't actual sexual advances, and you know, it shouldn't have had that effect on her. Then the other thing you sort of have to consider is banter, because that happens in a lot of offices and things like that. That's something that's quite it can be problematic depending on the form that it takes. What some people see as banter isn't necessarily what others do. But I guess in terms of a general rule, you just kind of have to be careful what you say and what employees say, and try and avoid any jokes that are of sexual in nature, I guess.
Yeah, or that cross the line. And I think what's nice is this is going to tie in very nicely to the question we've just been asked. So the question is about an ongoing sexual harassment allegation. The employee who has been accused, so the potential harasser in this situation, has stated really that both parties are engaging in sort of this workplace culture of banter or similar conduct or behaviour. And what this ties into, again, if we quickly run through the test, and I'm assuming for the person who's asked this question, we are satisfied that it is unwanted conduct in the general sense, in that the average person probably wouldn't want to be on receipt of it, that it triggers one of the protected characteristics and or is of a sexual nature, and that is potentially humiliating, degrading, etc., etc., etc. What this particular circumstance ties into, and whether somebody is playing back or not, and whether it's part of a broader workplace culture, to use the example there, is the reasonableness of it having that effect. There are cases that have gone both ways on this. Some cases where it's been very clear that an individual has engaged back in very, very similar conduct, has been making the jokes themselves, has been making similar jokes about themselves, have all concluded potentially that it may not be reasonable for a specific example to have had that effect. If somebody seems to be engaging willingly in that joke in return, why have they suddenly decided it's a form of harassment? The risk of that is twofold. Firstly, you are trying to defend a discrimination claim by saying your workplace has a discriminatory culture, which can be unhelpful. It doesn't sit particularly well. Yes, it arguably defends the claim. It can't be discriminatory against this individual because we treat everybody badly, is sort of what you're saying there. But ultimately, yes, you could defend the claim. You just maybe don't want that to be your implicit on-record argument. The other risk, of course, is that the tribunal and the technical guidance around this, and there's several forms of technical guidance to be looking at here. There's the basic technical guidance that accompanies the Equality Act. I think the one Justine's been referring to is the one that the EHRC issued after the 2023 change to legislation, which I'll come back to. Does make it clear that there are situations where people will unwillingly engage in this simply for the sake of making their life easier, and that's particularly true. I skim back to that second type of potential sexual harassment. There, it's perfectly possible for somebody to go along with unwanted sexual advances, for example, just for the sake of not raising their head above the parapet because they're concerned they might be discriminated against, they might lose their job, there might be backlash against them. They might not be believed. Let's not forget that part of the reason for this legislation is the number of genuine sexual harassment cases that don't get resolved. So to answer your question, okay, we've got, and just to give some more detail for everybody else, we've got WhatsApp texts, chats demonstrating that there is some back and forth here. It potentially plays in. It is a potential defence. but it will really depend on the exact nature of the harassment that's taken place and the exact nature of that back and forth. But yes, ultimately, whether the alleged victim, for lack of a better word, has been playing into similar conduct, in a sense, goes to all of these. Does it actually have that effect in the first place? And even if it does, is it reasonable for them to do so? Okay. Anything else from you, Justin?
No, I think that we've covered everything. I was going to pass over to you to deal with
the rest.
reasonable steps.
Let's just have a look at this other question that's popped in because it looks like it's potentially relevant. An issue has been raised relating to sexual harassment. If that's only verbal, would it still need to be investigated? I will come back to that in a little bit more detail, but basically I think in order to more widely demonstrate that compliance with reasonable steps and all reasonable steps, ultimately yes. The difficulty, of course, is going to be is you might have I really hate using the word victim because it doesn't really sit nicely with me. So the person who has been harassed, or you could say harassee, I suppose. If you don't have their cooperation, it's obviously quite hard to investigate, and that will be an issue. But yeah, bear with me. We'll come back to what you should do in those kind of situations in a little bit more detail. So, the Worker Protection Amendment to the Equality Act 2010 Act 2023, usual snappy title for employment law updates. As we all know, that one kicked in as of last year. It introduced this reasonable steps duty on employers to proactively seek to prevent sexual harassment from taking place. The key real element of this, I think, is that phrase, in the course of employment. And we all know at the time there was some back and forth there to kind of question whether that meant that it did create this extension to whether third parties were the harasser or not. The conclusion there, and ultimately it will make no difference because of the changes coming in the Employment Rights Bill, is that using the phrase in the course of your employment creates a context, it doesn't limit. So what the duty, strictly speaking, is to take those reasonable steps to prevent employees from being subject to sexual harassment in the course of their employment. It doesn't limit that as by whom, it doesn't limit that as to in what circumstances, it is in the course of their employment. So it's absolutely reasonable to assume that the current position is that duty applies to take preventative steps in relation to third parties as well. So what is therefore meant by reasonable steps? Well, again, we haven't really been told yet. In the grand scheme of employment tribunal proceedings, legislation, case law development, this is still a relatively new piece of legislation. Those of you who were at the mock tribunal event we did in June will know that I actually posed that question to a couple of the barristers and said, has this started filtering its way through to you yet, and sort of your side of the litigation? And they both said no at that point. So I think it's safe to assume that 2.5 months on, that's still the case. So there's no case law yet that I'm aware of on what exactly reasonable steps would be in this situation, but inevitably all of the guidance around this, whether that's come from us, whether it's come from institutions like the CIPD, has been that this is very much all the stuff you would expect to be doing anyways. It is policies, it is review of procedures, it is having reporting and investigative processes in place. So coming back to that question, yes, if you're having to demonstrate that you've taken reasonable steps to prevent a reoccurrence of that original act of harassment is potentially to have investigated the one that's already happened. So what this has allowed, I think, is a slow shift in the approach and to start treating this more as something that, as employers, we need to be proactively doing, and what steps we should be doing to make sure that the situation, as far as we can, doesn't arise in the first place. The fact that it is a proactive duty arguably makes it slightly more onerous than the reasonable adjustments for disability, which is a comparison I'll come back to later. But ultimately, yes, the current law is this proactive reasonable steps duty. Coming back, as I said I would, to the EHRC guidance from 2024, they gave some useful examples of what could and couldn't qualify here. One thing that is absolutely clear from that guidance is risk assessments are crucial. And I think that's a fair thing to say. If you were in court and the question you are potentially asked is ultimately, what were you doing to ensure that sexual harassment didn't take place? You are going to struggle to answer that question if you haven't risk assessed scenarios where it might happen. It's exactly the same as a health and safety style risk assessment. How can you show that you mitigated the risk of an injury if you haven't established a situation where the injury might take place? Key factors, I think, that are definitely worth considering within that risk assessment, people who are working out of hours, lone working, and I would also suggest remote working. Don't forget, if we're triggering third party here, then somebody working off site, you don't have that same level of site security and control that you maybe have in an office or a factory location. The use of alcohol at social events, particularly work parties, there's plenty of case law on that. I won't ruin a potential future session on Christmas parties by talking about that now. But obviously work events can and often are considered an extension of the workplace. Power imbalances or gender imbalances in certain institutions. There is no sweeping generalisation that men are more likely to commit sexual harassment or that certain groups of people are more likely to commit sexual harassment. You won't successfully argue that, but the presence of particularly a gender and power imbalance could be indicative of an increased risk of sexual harassment. And I suppose the last one, social media contact. If you're the kind of organisation that actively encourages your staff to engage in social media platforms as part of a marketing, networking, those sorts of things, then you are also opening them to the risk of social media presence, trolling, abuse, all of those sorts of things. That is an area of risk that also needs to be considered. That would be a form of harassment being conducted by a third party. At the moment, if that's sexual in nature, we're caught by the law as it stands. In the future, if it's any form of harassment, then we may well be caught by the changes proposed under the Employment Rights Bill. Reasonable steps, I said I'd come back to kind of this comparison with disability discrimination and reasonable adjustments. It's not a great analogy, but given we're not actually told yet what reasonable steps would be, reasonable adjustments is a good place to start. Obviously, with reasonable adjustments, we're looking at two things. The adjustment, does it help come over the substantial disadvantage the disabled person is suffering? And is it reasonable in the context of the employer, considering their costs, their resources, their size? And I think you can apply a broadly similar test here as well when you're deciding whether something is a potential reasonable step. And I think, again, it's a twofold test. Is it something that is actually likely to mitigate the risk of sexual harassment from taking place? That's the step. And then the reasonableness of it ties into, can we effectively implement that? What is the cost-benefit analysis of doing so? Don't forget, the tribunal is not going to accept it was too expensive as a reason not to do something. It would have to be grossly disproportionately so. But if you're going to use that comparison and apply the same sort of test, remember that for sexual harassment, this is a lot wider. Disability reasonable adjustment is that specific individual's needs to overcome a specific disadvantage. For sexual harassment, we're looking at any steps that could be taken to prevent sexual harassment taking place at all. It is a much more proactive duty than a reactive one that we see in reasonable adjustments. The other place that's worth looking still at the moment is the 8-step guide, also from the EHRC. It does set out sort of 8 things that you should be doing, thinking about, and some key guidance around those. The EHRC, any documentation they produce can be waved around in the employment tribunal, so it is a useful thing to highlight, to look at, and if you're having to defend a claim, to say we worked through this process and that's what the sort of central guidance on this thing is. So that can always be useful as well. As with any policy, any change, any process, the last one there, of course, ongoing monitoring and effectiveness. Keep an eye on what's going on, particularly where, as I've said in point 3 there, we're trying to engage with staff to find out what problems might exist, where they see areas of concern, and ensuring that they feel comfortable in speaking out about issues. The risk of a failure to comply at the moment is an ACAS uplift to any associated award. It is similar to a failure to follow the code of practice in relation to a grievance or a disciplinary process, so it is that up to 25% uplift. The HRC itself does also have enforcement powers in relation to these duties. They can take action themselves. The other thing worth pointing out, I haven't mentioned it later in the Employment Rights Bill part of this, but the government are talking about introducing a central Fair Work agency to deal with breaches of specific areas of employment rights. I suspect this one will ultimately fall under some kind of combined jurisdiction of the EHRC, the tribunals, and that Fair Work Agency. So all of that should be something we're familiar with. If you're not doing those things already, suggest you start very quickly because it's getting worse. The Employment Rights Bill, which still is not law yet, still has not been finalised to the best of my knowledge, and is still being picked apart by both sides of the House of Parliament at the moment. It is very much pending. It's sort of a case of any day now. We're expecting royal assent at some point in the next couple of months. The government have already produced a roadmap for implementation on the assumption that it's going to become law. So I think we can safely say that even if the House of Lords starts to take further issue with it, it will be forced through in one way or another. As I said at the start, update on that in person the end of this month. I will also do next month's session on these as a condensed version of that, just to run through the roadmap. But for our purposes today, the big thing it does is it upgrades that reasonable steps to all reasonable steps. It's an enhanced preventative duty to one we already don't have clear guidance on. So not only do we not know what reasonable steps were initially, we've now got to do more in theory, still without knowing what they are, which is incredibly helpful. That said, the current roadmap for the all reasonable steps change is October of next year. So we've got about 12 months to figure it out between us and then hope we're all right. And I think this is why most of the advice, certainly that we've been giving, and I think that I've seen from the EHRC and other institutions, has been quite extreme. I think it's been in the expectation that this was going to make its way through, and that most of those steps we're talking about would also qualify towards all reasonable steps. I will come on to that in a bit more detail. Jumping down a couple of points there, we are also going to see liability for third-party harassment extended to all protected characteristics. It's already written in the legislation. The Equality Act in principle allowed for this anyway. It was there in 2010 when it was drafted. It hasn't been on the books for basically the entirety of that period, but this is one of those ones that people are concerned about. So all of those questions we had earlier about bystanders, yes, a bystander can claim harassment, but now, of course, somebody can claim harassment if a third party harasses them and you have not taken steps to prevent that. Lots of questions will come up about that over the course of its implementation. I may well do, once we know exactly what the law is going to be, since it's still in draft stage, I may well do a dedicated session just on that at some point next year, because I can see a lot of clashes. We've already, and I've talked in previous sessions, got these clashes between, for example, somebody's right to gender identity expression, somebody's right to have an opinion about that. This is going to be a prime example of where we get more clashes there in the future. So yes, this is something we can obviously look at in more detail, but be aware it's coming in. Beyond this, we've also got whistleblowing style protections for people who make disclosures about sexual harassment. It doesn't technically fall within that list of protected disclosures at the moment. They tend to relate to breaches of legal obligations, health and safety, environmental damage, all of those sorts of things. The intention is basically to slot a disclosure of sexual harassment into the protected interest disclosure list. That means that somebody doing so will have all of the protections associated with a whistleblower. So if they are the harassee, not only will they have their protections associated with sexual harassment law, but they will also have whistleblowing protections not to face detriment or dismissal simply as a result of having raised it. Realistically, I'm not entirely sure what additional protection that gives them that's not already there. One would argue it was a victimisation claim anyway, if they've raised an allegation or taken steps to identify it as a potential Equality Act breach. But I think it's designed very much by the government here to go, we're taking this seriously, folks. Here's something else they could do. I suppose in principle, it would also give them an automatic unfair dismissal claim, for example, or something additional to the associated victimisation claim. Again, just as a further example of that, I would probably argue that disclosing a failure to comply with your legal duty to prevent sexual harassment probably falls under the definition of something that you're legally bound to do for the purposes of protected disclosure anyway. It feels a bit sledgehammer walnut, I think, but it is there, and again, an important one to be wary of. The only other one I'll mention there is ban, restriction, and confidentiality restrictions. The best example of those, of course, is the confidentiality provisions you often put in a settlement agreement. To all intents and purposes, when that comes in, and for avoidance of doubt, I put these in a bad order, but the middle two of those, there's no enactment date yet for those as far as I'm aware. But those kind of restrictions that prevent people from talking about harassment, particularly sexual harassment, are going to be deemed void and unenforceable if that comes into place. I think my concern with that is it arguably demotivates us as employers to enter into settlement at all. I can understand the logic behind it. I can understand the desire to report sexual harassment. We already don't prevent people as a general rule from disclosing it where it also amounts to a criminal offence. But my concern would be one of the major motivators for us as employers to enter into a settlement agreement is that confidentiality element over potential claims. We're not admitting that sexual harassment took place by signing one of those documents, and I think it potentially creates the argument that that whole process becomes a bit more employee-sided. Arguably, all you're getting by signing a settlement agreement at that point is they won't take you to court. It doesn't stop them going and talking to the media. So those are the changes which are looking like they are coming in over the next year or so, October 2026 being our sort of big important one for the purposes of today's conversation. What are the all reasonable steps that we're potentially looking at? Well, the Employment Rights Bill does allow for regulations to specify this. The current roadmap says that all reasonable steps comes in October 2026. The regulations telling us what they will be comes in 2027. So, big picture again, we've currently got reasonable steps. We don't know what they are officially. We've got all reasonable steps coming in a year's time, and we'll know what they are at some point the following year. Thank you, Labour. That said, I think we can make some fair assumptions as we've been doing during the course of today's session. It's going to be everything set out in the current guidance. I think almost all of that is going to qualify as reasonable steps anyway. Once we've got these regulations from as and when 2027 in theory, it will be certainly whatever is within there. But then don't forget there's also this obligation on you to consider it within the specific circumstances as well. So it's all fine and good having a risk assessment, having policies, having procedures, etc., etc., etc. If there is a specific circumstance which you have identified, perhaps within your risk assessment or that is specific to your workplace, which you then haven't addressed, that's still going to cause you to fall foul, even though it's one that might not be listed in the regulations. In exactly the same way that if you had a hypothetical list of reasonable adjustments for somebody with a certain medical condition, the simple fact that you follow all of those but somebody is still suffering a disadvantage which you could have rectified does still give them a right to bring a claim. It's exactly the same logic. So I think immediate steps, definitely start building in risk assessments if you haven't already done them. That's an easy place to start identifying possible areas of risk, and to start updating, publishing policies, and of course to make it clear that staff are trained in basically don't sexually harass each other, and it really is that simple. I think people need to be aware of what it is, what the risks are, and to be honest, a useful element of training to staff is still that they can be held personally liable. If you need the stick as much as you need the carrot, it's about reminding them that they can be named as individuals in a tribunal claim and that they're potentially also committing a criminal offence. Beyond that then, that's sort of it in terms of the main part of the talk. We had a couple of questions that came through in advance of the session which we'll start to discuss now. I suspect people will have some they want to bring up based on what we've said so far, or possibly comments that arise out of the discussion we're about to have. So we'll sort of spend the next maybe 10 minutes or so going through those and then see where we are. So the first question that I had come through in effect was this: how do I deal with harassment, whether that's sexual harassment currently or any form of harassment in the future, where that is committed by somebody I've got no control over? So this is that third-party harassment argument, isn't it? The specific question I had really was how do I investigate that? Justin, your immediate thoughts?
I guess if you don't, you have to do as much as you can. It's going back to the reasonable steps discussion, which is as much as you can, investigate it, look into it, speak to the person who it happened to. If you can speak to that third party, then obviously do that. But I appreciate in some circumstances when they're out of your control, that is difficult to do. And I understand that, that's a difficult thing to balance. So yeah, it's just doing as much as you can to be able to investigate and putting in steps after you've investigated to prevent it from happening again. So things like if it was an event, doing some sort of risk assessment specifically for that event. And just after the event, taking steps to prevent it happening again.
Yeah, so I mean, I think there's two obvious examples of this, isn't there? There's the one that maybe we're more likely to experience, for example, harassment by a client.
Yeah.
As a prime example, how do you deal with that? Well, it doesn't stop you investigating the entire thing internally. You've still got a recipient of that conduct to talk to and investigate. You may have internal witnesses. You're still under an obligation as an employer to make sure that doesn't happen again. You're under an obligation to make sure it didn't happen in the first place.
Yeah.
Now that it's happened, you've now got to take appropriate steps and show that. Okay, we've got no control over the client. We can't force them to come in and conduct an interview. But one of the questions the firm would have to be asking itself is, do we terminate that relationship? Is that grounds for us to do so and to terminate our retainer with that client? And it sort of goes back to what I was saying earlier about that cost-benefit analysis argument. Can we rely on our commercial relationship with that individual or that entity as superseding the individual's right not to be sexually harassed? Probably not.
Yeah.
And again, it'd be one of those examples where it differs depending on who it is. If that's an individual client, there's no alternative arrangement there, is there? We might be able to create a situation where they deal with a different fee earner, but there's no guarantee there's not going to be a repeat of that conduct. If it's a commercial client and it's a particular member of staff who is a point of contact from that client, then maybe we need to talk about changing who that point of contact is or changing how that relationship operates. And yes, this will start to play into your commercial relationships with other people. It's exactly the same, I suppose, for those of you who, to deal with my next example, would be maybe contractors or other people in more commercial relationships.
Yeah.
Your duty is to your member of staff first and foremost. That is clearly an absolute duty as suggested under the proposed legislation. It's an active preventative duty. If that means that the two CEOs have to phone each other up and say, this is completely unacceptable, we need to work something out here, or we're potentially talking about not being able to work together, then that is a conversation that may simply have to happen. And I appreciate that is not one that anybody on this call is going to be thrilled about the idea of doing. So to answer one of the questions, could we ask for policies and things like modern slavery state? Yes, if you're contracting with a third party, you're more than entitled to ask what are they doing in order to help prevent sexual harassment, for example, in exactly the same way you would for modern slavery or GDPR compliance as well. No reason not to ask, and I think you're entitled to be very suspicious if they refuse to provide it. Any organisation where they are in a situation where they've got workers of their own who are going on sites will increasingly want to have policies that cut both ways in exactly the same way we do for data protection now. How am I protecting my staff when they're on your site? And equally, how am I protecting your staff when my staff are on your site? Because there is a clear situation there where you could have two employers potentially liable for the same event.
Yeah.
And that's going to be a fun one to navigate. If a claim against the employer is taken, can we have the third party as a counterclaimant? That's an interesting question. Not one I've considered in detail yet, but I'm thinking about a circumstance. So, not necessarily a counterclaimant, but of course, one option potentially is for the employee who is bringing that claim to name the third party as a co-respondent. That's certainly somebody they could bring in if they chose to do so. And there, of course, I suppose, under vicarious liability principles, the employer of that third party could become indirectly liable. So I can see that eventuality arising, and there may well have to be some case law on this to identify in what situation it's appropriate to have the third party's employer conjoined. I think that's a question that's going to rely on exactly how the legislation is specifically worded, and there will be a test case on this at some point. The problem with being such new legislation. I can see that eventuality arising. Whether you could take any action against them directly, that would be a question of your commercial contract with them potentially. If it's a contractor, for example, in principle, there is nothing stopping you negotiating a term into a commercial contract that says any sexual harassment conducted by a member of your staff against mine, you indemnify me for.
Yeah.
In principle, that could exist in a commercial contract, and then you've got a contractual obligation that you pursue them under. That led to some interesting points, didn't it? I do think this is going to be one of those things that creates a lot of problems for the courts very early on. It opens up sexual harassment so much, and indeed other forms of harassment in due course. We've all seen in the media the kind of examples of pubs saying, well, what if my workers get offended by two people having a chat over a beer? Yes, that risk is there.
Yeah. I
mean, in that situation, you're going to struggle to conjoin that client as a co-respondent.
Yeah.
I do think that's going to be hard. Before I move on, I've got a question here. Okay, so it's more reasonable adjustments in disability related, so I'll come back to that one at the end if that's okay. I think that sort of answers question one as best we can at this stage. So. Yes, your obligation is still to investigate internally, seems to be the gist of it. If there's any scope for you to be able to bring in the third party, perhaps under a commercial arrangement, if that's been permitted, or perhaps your relationship, or to ask the third party employer to conduct their own version, because don't forget that's arguably an act of gross misconduct at their end. They should be investigating as well.
Yeah.
Problem with that, of course, overlapping GDPR obligations. You're going to have to decide what your reasonable, lawful means of processing that data across two potential institutions would be. Definitely a minefield in the making. Question two, I've sort of covered, I suppose, already. What's the difference between reasonable steps and all reasonable steps, and what more should I be doing? I think that boils down to identifying the specific circumstances that you have established under your risk assessment and under your internal review of the situation to decide what may need doing. All of the guidance has referred to things that we've talked about, whether there are gender imbalances, whether there's power imbalances, whether there's people alone working, home working, all of those sorts of things. But again, you might identify that you've got a particularly vulnerable member of staff who is a home worker, which the guidance itself may not cover. Purely hypothetical, it probably does. But your obligation will be under all reasonable steps to consider, in effect, absolutely everything you can do for that individual to ensure that they don't experience harassment. And that is going to mean, probably in their case, making sure that they've got dedicated points of contact they're aware of, that they've got ways of highlighting and flagging issues as and when they arise, that the reporting mechanism is in place, and potentially that, I'm trying to think of a good example now, but maybe if they've got concerns about incoming correspondence, social media platforms, anything like that, that there is an easy mechanism for that to be either filtered or monitored in some way without it invading that individual's privacy. All reasonable steps is exactly what it says on the tin. It's any step that you could legitimately take in those circumstances without it disproportionately affecting you, but which could actively prevent harassment from taking place. There will be case law on this in due course, I'm sure, but going back to that example I keep using on the reasonable adjustments, we know how broad that can be, and we know how those arguments run. This is a step beyond that, arguably in the employee's favour. And do you want to add to that? Or?
No, I think you've covered everything, to be fair.
Yeah, I mean, today's session is intended as a little bit of a warning shot. It's difficult to give absolute answers because we don't have that guidance yet. We don't have what the government, or really what the EHRC would consider to be those reasonable steps yet. So that is it from us at the moment on that. I'll just start talking for a minute about other things that are coming up while anybody throws in any final questions. Then I'll finish this session and come back to the sort of unrelated question that we've had. So before I come on to the next session, firstly, thank you, Justine. I know that was your first full proper session with me. So thank you for joining us. I think it was a good one to start.
Yeah.
The next one of these, Wednesday, the 1st of October, first Wednesday of the month, as always, I will look at the Employment Rights Bill in more detail there. Like I say, for those of you who are around local, or indeed not local, and want to come down for half a day, we've got an in-person event towards the end of this month, which will be a much more comprehensive version of that. Obviously, I can only do what I can in sort of 40, 50 minutes within that session. So much more detailed version in person with us all. If you've not had correspondence about that, please let me or the events team know. Otherwise, that's our immediate next session. November's, I'm looking to do a session on AI in the workplace, hopefully, and sort of the creeping introduction of AI, or I suppose more accurately, LLMs, large language models. December, we may look to do one again on topic to be decided.
Yeah.
Either something of interest, or we might kind of do our cliche sort of Christmas parties type thing that we've hinted at. We'll think of something. If anybody's got any suggestions on anything they particularly want us to talk about, though, please, as always, let us know, and we'll see where we are rolling into next year. Otherwise, unless people want to hang around for the questions that have been asked, I will stop the recording in a moment. Thank you for joining us. Thank you again, Justine, for coming on. Have a good month, everybody. Have a good rest of your day. And for those of you I don't speak to beforehand, I will see you in October. Thank you for joining us.